Judgment in the Appeals Times newspapers limited and Flood, Miller and Associated Newspapers, Frost and Others, and MGN Limited.
These three appeals each involve a challenge to an order for costs made against a newspaper following a trial at which the newspaper had been held liable for damages to the claimants. In the Flood and Miller cases, the newspapers were held to have libelled the claimants, and in the Frost case, the claimants established that the newspaper had unlawfully gathered private information about them by hacking into their phones. In each case, the newspaper, having lost at trial, was ordered to pay the claimants' costs. In all three cases, the claimants had taken advantage of the costs regime introduced in 1999. This regime enabled, first, the claimants' lawyers to agree to be paid nothing if the claim failed, but to receive up to twice their normal fee, known as the success fee, if the claim succeeded. Secondly, the claimant could take out insurance against the risk of having to pay the defendant's costs. And thirdly, the claimant was able to recover from the defendant all his costs, including the success fee and the insurance premium, if his claim succeeded. The regime was replaced for most claims begun after April 2013, but not for defamation or privacy claims, the costs of which are currently the subject of public consultation. In each of the present three cases, the judge decided that the newspapers should pay the claimants their costs, including the success fee and the insurance premium under the 1999 regime. The newspapers unsuccessfully appealed to the Court of Appeal and now appeal to this court. In each appeal, the newspaper relies upon the decision of the European Court of Human Rights in MGN against the UK, where it was held, in that case, that a newspaper's right to freedom of expression under Article 10 of the European Convention was infringed by an order in a privacy case requiring it to reimburse the success fee and insurance premium incurred by the successful claimant. In the Flood case, the newspaper also contends that the cost order made against it was unreasonable in any event. Today, the Supreme Court unanimously dismisses the newspaper's appeals in all three cases. Because the government is not a party to these appeals, it would be inappropriate to decide whether there is a general rule in domestic law that it would normally infringe a newspaper's Article 10 rights to require it to reimburse a claimant's success fee and insurance premium under the 1999 regime, because it is unnecessary to decide the point. Assuming that there is such a general rule, to deny the claimants in the Miller and Flood cases the ability to recover the success fee and insurance premium which they had incurred would infringe their rights under Article 1 of the First Protocol to the Convention. They funded their claims on the basis of the law as it was, and in the legitimate expectation that the law would not be retrospectively invalidated or changed to their detriment. Even if upholding the costs orders would infringe the newspaper's Article 10 rights, the fundamental principle that citizens are entitled to assume that the law will not be changed retrospectively would be directly infringed by the order which the newspapers seek. Freedom of expression is also, of course, a fundamental principle, but it is less centrally engaged by the costs issue in the Flood and Miller cases. The just and appropriate order under Section 8, subsection 1 of the Human Rights Act 1998 is therefore to dismiss the appeals, because to allow them would be a graver infringement of the claimant's rights than the newspapers would suffer if the appeals were dismissed. The same reasoning applies in Frost, but in addition, the general rule would not in any event have applied. The information in that case was obtained illegally, and there could have been no real expectation that its publication would be in the public interest, and therefore the newspaper's Article 10 rights are only very marginally engaged. In the Flood case, the newspaper had defeated Mr. Flood's claim in relation to the original publication, but it had failed in relation to the electronic version of the story, which the newspaper had not taken down when it should have done. Contrary to the newspaper's argument, the trial judge was entitled in those circumstances to award the claimant all his costs, as he was on the face of it the winner. Most of the costs would have been incurred anyway, and the newspaper had adopted an aggressive and unconstructive attitude in negotiations.